I'm happy to have this opportunity to talk to you about the changes in the law that were brought about by the passage of Proposition 36. So, by way of introduction, I'm the chief of the Major Narcotics Division at the San Diego County District Attorney's Office. Just last week, I celebrated my 25th year in the office. And I also had the pleasure and the honor of working with a legislative subcommittee of the California District Attorneys Association in the drafting of portions of Proposition 36. And given my role in the Major Narcotics Division, I was mostly focused on the language that relates to the drug components of the proposition. But of course, I've become very familiar working with that subcommittee and now with the implementation of the law on all the theft components. And that's what I'm going to talk to you all about this morning. So you're going to hear from a lawyer talking to you about the law. And so I hope you brewed some really strong coffee, but hopefully you find it interesting as well. And what would a talk by a lawyer be without a disclaimer right up front? The first part just being that these are my own views and not the views of anyone else, my opinions. I hope for my sake that District Attorney Summer Seffin shares those views, but at least for purposes of this meeting and this presentation, these are my views. And also, you shouldn't consider anything that I'm saying here today as either professional advice or legal advice. And the last part is that on all of these types of presentations, it's not uncommon that you'll hear please don't screen capture or photograph presentations. But as Marla just said, this will be made available on the SUOPT website at a later time. If you want to screen capture stuff or photograph, that's fine as long as it's for informational purposes. There's nothing wrong with that. We just want to make sure it's used appropriately. Let's go ahead and dive in. An overview of what I'm going to talk to you about this morning is this Proposition 36, known as the Homelessness, Drug Addiction, and Theft Reduction Act, passed in November 5, 2024, and then went into effect on December 18th of 2024. So it is now the law, and it passed overwhelmingly. All 58 counties in the state of California, it passed, and it passed by just over 68% of the vote. That's 10,300,000 plus votes in the state of California in favor of this proposition. That is a clear mandate that change was needed. And the public was hugely in support of the reforms. And that's really what you need to think about in Proposition 36, is it wasn't eliminating other laws, but it was amending some past laws, and primarily Proposition 47, which passed by voters back in 2014. And those changes in the law, and I'll talk about that a little bit more as I get deeper into the presentation, but they had what many believe to be a very negative and significant impact, causing a rise in homelessness, a rise in drug addiction, a rise in theft, all kinds of theft, the retail thefts that we see, and then I'm going to talk about the thefts from your home. And so Proposition 36 was really geared towards addressing those significant increases in primarily chronic offenders, those people who just continue to repeat these crimes, either having no consequences for their drug use, no consequences for their acts of theft, but also balancing out what happens with these individuals. Meaning the proposition was never geared towards just arresting people and locking them up. It is a balanced, measured approach that brings accountability to those people who violate the law, but also it incentivizes those individuals to accept and successfully complete treatment. And I'm going to go over that as well. So in the realm of the controlled substances, as now provided by Proposition 36, I'm going to talk to you about Alexandra's Law, what we have called here in the San Diego County, the Drug Death Advisal. And we've been using it for some time, even before Proposition 36, but now it's the law throughout the entire state of California. I'm going to talk to you about the law as it's been amended regarding drugs in combination with firearms. We'll talk about weight enhancements with those large quantities, those cases that we see often with large quantities of drugs and the increased penalties that come for people that are in possession of a large quantity of drugs in their sales-related activity. There's injury enhancements that have been added by the passage of Proposition 36. And then the big one is the treatment mandated felony. And I'll spend some time on treatment mandated felonies, what those are, and what they're designed to accomplish. In the realm of the theft crimes from Proposition 36, we're going to talk about aggregation of value, just adding up value and what that means. And the return of the ability for prosecutors to charge petty theft with qualifying priors as a felony offense. That went away with the passage of Proposition 47. It's now back and an option. And then we're going to talk about two enhancements that got added by Proposition 36, including what's called an excessive takings enhancement and also an acting in concert enhancement. So this is Alexandra Capelouto. Alexandra was 20 years old, having trouble sleeping. So she made the unfortunate decision to order what she believed was a Percocet from an individual on Snapchat. And I'm sure you all know how this story ends. That Percocet was not in fact Percocet. It was a counterfeit pill made to look exactly like a Percocet. And Alexandra took that pill and she died as a result. After her death, her parents, the Capeloutos, became very active in trying to get legislation passed that would warn drug dealers that what they were doing was taking lives. And if they continued doing that and someone died as a result, that they could be charged with a homicide up to and including the crime of murder. A warning is all they wanted. And since 2019, the Capeloutos went before our legislature in California, up in Sacramento, and 5 times over the course of 4 years, attempted to have this type of warning made into the law in the state of California. Sadly, their efforts never made it past the Assembly or the Senate's Public Safety Committees. It's what we call died in committee and never made it to a floor vote in either of the houses of legislature. But with Proposition 36, Alexandra's law was included, and it is now the law in the state of California. So I'm going to go ahead and read this. This is what defendants now who are convicted of a drug sales related offense are going to hear by law from a court and then be included within the record of conviction. And it is extremely dangerous and deadly to human life to illicitly manufacture, distribute, sell, furnish, administer, or give away any drugs in any form, including real or counterfeit pills. You can kill someone by engaging in this conduct. All drugs and counterfeit pills are dangerous to human life. These substances alone or mixed kill human beings in very small doses. If you illicitly manufacture, distribute, sell, furnish, administer, or give away any real or counterfeit drugs or pills, and that conduct results in the death of a human being, you could be charged with a homicide, up to and including the crime of murder, within the meaning of Section 187 of the Penal Code. So that may sound familiar to some of you. It's very, very similar to what is known, at least in the legal circles, as the Watson advisal. And some people will call this the Watson advisal, and it is kind of what it was modeled after. But the Watson advisal happens in the context of driving under the influence cases. So people who are convicted of a DUI, they get a very similar advisal that warns them that if they continue to drive in the future, drive drunk or under the influence of drugs in the future, and as a result, someone dies, they could be charged with a homicide up to and including the crime of murder. That Watson advisal in the DUI context has been in existence since 1981, and it's used every single day in courthouses throughout the state. So it's unclear to me exactly what the pushback was and why this advisal never made it through the public safety committees at the legislature. But it's here now, and it's about time and it's appropriate. And so that's Alexandra's law. The law applies to those dealers of hard drugs. And hard drugs are defined as those drugs that are contained within Health and Safety Code section 11054, that's Schedule 1 drugs, or Health and Safety Code section 11055, Schedule 2 drugs. The most common ones that we see in our work and that you're all familiar with are fentanyl, cocaine, heroin, cocaine base, methamphetamine, PCP. But Schedule 1 and 2 is much broader than that. And many of those additional drugs are also considered hard drugs. The nitazines that you've probably heard about in the news, those are also Schedule 1 drugs. We've got heroin and cocaine base, those are Schedule 1 drugs. Other Schedule 2 drugs are like hydrocodone, oxycodone, morphine. So all those are considered hard drugs. But specifically excluded, even though these are Schedule 1 drugs, are things like cannabis, peyote, LSD, and then other psychedelic drugs, psilocybin, what you might find in those psychedelic mushrooms, dimethyltryptamine, or commonly called DMT. If you're not familiar with DMT, I suggest you watch Joe Rogan's podcast, and he has episodes on DMT. And maybe you don't watch this podcast, but all those are excluded. Those are not, those people don't get advised. But here's something important to recognize about this Alexandra's law and this advisal that these defendants are receiving. First, they have to be convicted of a sales-related offense. And you'll hear me talk about that throughout this presentation. Sales-related, what does that mean? It means someone sold the drug, they possessed it for purposes of sale, or they transported it for purposes of sale, or they manufactured the drug. That's what we're talking about. We're not talking about people who merely possess drugs. And the other thing that's important with this type of advisal to understand is that this doesn't mean that a person will be charged with murder. The goal of these advisal is to educate those people who are dealing in these dangerous substances that are taking so many lives in our communities across this country, that what they are doing is in fact responsible for that loss of life. And if they continue doing it and someone dies, there's a possibility. This is not, they don't automatically get charged with murder or anything else. The hope and the goal is they change their conduct. They find another way of action. Moving to drugs and guns. With Proposition 36, what happened with 11370.1 of the Health and Safety Code was just the inclusion of fentanyl in an already existing law. So 11370.1 is not new to our statutes. It has always been a crime to possess any amount of these controlled substances, the cocaine, heroin, methamphetamine, and phencyclidine or PCP, with a loaded operable firearm. And all Proposition 36 did here was specifically include fentanyl into that list. This one is an enhancement. It's Penal Code Section 12022, subdivision C1. And this provides that an additional punishment of 3, 4, or 5 years for a person who is personally armed during the commission of a drug sales-related offense. Again, sales, possession for sale, transportation for sale, or manufacturing. The change that Proposition did here, and again, this is a law that was already on the books, is it changed that from a local prison, I'll describe what that means in just a bit, changed it from a local prison offense to a state prison offense. if a defendant is in fact sent to prison. When it comes to weight enhancements, and here, particularly in San Diego County, I'm sure this is not unique to us, but here, being with our proximity to the border, it is not uncommon. In fact, it's common that we will see large, significant loads of controlled substances coming across the border through our ports of entry into San Diego County, through our county, up to all of your counties who are watching north of us and east of us. But weight enhancements have existed also for quite some time. And under 11370.4 of the Health and Safety Code, if a person is convicted of a sales-related offense involving certain quantities of drugs, and the column on your left, you can see is heroin, cocaine base, cocaine. In the center, methamphetamine, amphetamine, and PCP. And then to the right column is fentanyl. Each of these list out if you have a substance containing more than, starting at 1 kilo when it comes to the first two columns on the left and in the center. 1 kilo, you'll get plus 3 years. And then it goes down. I'm not going to read them all to you, but it goes down. It starts getting higher and higher the larger the quantity of the drugs contained. And what Proposition 36 did was it created a special, new subdivision that related strictly to fentanyl. And starting at an ounce. And so now with an ounce, 28.35 grams of fentanyl, you get an additional 3 years added to whatever the underlying punishment would be. Let's say if it was the possession for sale of fentanyl, and you had over an ounce of that drug, a substance containing fentanyl, you could get, we would allege, and you could be convicted of, and you would be sentenced of an additional 3 years in addition to the time you would receive for the possession for sale. And I highlighted in red the kilo quantities in each of these columns, and you can see with the first two, it was an additional 3 years. With fentanyl, it's an additional 10 years. And why is that? The obvious answer is because fentanyl is so much more potent, so much deadlier than the other drugs. It takes so little of the fentanyl to take a life, that the punishment is commensurate with that risk, with that harm, and with the smaller quantities needed by the drug traffickers, both in trafficking and in their sales to make their profits. So that's the weight enhancement. The other change that the proposition did when it comes to these weight enhancements is that it made the punishment state prison eligible. And you'll hear me throughout talking about state prison and local prison. You only get to state prison if a court, after your conviction, decides that they're not going to grant you probation. The vast majority of our defendants are granted probation, and probation allows them for a period of time, normally 2 years with a felony, 1 year with a misdemeanor, to complete whatever conditions the court feels are appropriate. Those conditions get ordered, the defendant completes those, and upon successful completion of those probation conditions, probation is terminated, case is over. They don't go to state prison. Now, with some people who have a history of convictions and have shown that they are not an appropriate candidate for probation, that they will not succeed on probation, or for offenses that are just so serious that probation is not appropriate, even if it's the first offense, then a court can send someone to prison. And that is either going to be state prison or local prison. And again, I'll talk about that a little bit more in just a bit. Another thing that the Proposition 36 addressed was the ability of prosecutors to allege what is called an injury enhancement. And existing law, even before Proposition 36, was that if a person committed a felony offense, and during the commission of that felony, someone suffered great bodily injury, someone other than an accomplice in the commission of the offense, then we could allege and they could be convicted of and suffer an additional enhancement of 3 years in prison, in state prison as a result of personally inflicting that great bodily injury. Prior to the passage of Proposition 36, in San Diego County at least, we had been adding these injury enhancements in the context of drug overdoses. And there were cases, on occasion, we would file homicide charges in our drug overdose cases when we felt they were appropriate. And we have, in total to date, have filed about 10 homicide charges, a mixture of murder and voluntary manslaughter. But then there's a number of cases short of a homicide, but what we felt was worth more than just a straight sales offense for someone who sold a drug that resulted in the death of the user. And so we started adding these injury enhancements and arguing that that sale was a personal infliction. And many counties throughout the state were doing that and getting at least some additional measure of accountability, that additional 3 years added to that offense of sales. But great bodily injury, it's defined in the code as significant or substantial physical injury. You may be asking, well, what's significant or substantial physical injury? And then we would need to turn to case law and turn to common sense. A bad bruise, a scrape, even a minor cut, probably not great bodily injury. Broken nose, loss of consciousness, maybe a loss of consciousness from an overdose. I think we could argue convincingly that that does constitute great bodily injury. But we ran into problems in June of 2021 when the California Supreme Court heard the case of People versus Oyo. I pronounce it Oyo. I've heard it pronounced a bunch of different ways. So apologies if that's not the actual pronunciation. But Oyo was a case that in 2021 came down and examined what personal infliction in the context of a drug death or a drug overdose case needed to look like. A little bit about the facts of People versus Oyo. So Mr. Oyo was 18 years old, and he sent a text message to his 16-year-old girlfriend, Raina. And he told Raina in that text message that he had some cocaine. Raina came over to Mr. Oyo's apartment. She cut 2 lines into that cocaine. She ingested one of those lines. Mr. Oyo did not use any of the drugs. They both shortly thereafter went to sleep. Mr. Oyo woke up and Raina did not. Toxicology later showed that that cocaine was in fact fentanyl. And so Mr. Oyo was charged with furnishing controlled substance to a minor, and the prosecutor had added the 12022.7 injury enhancement. He was convicted of that as well at trial, and an additional 3 years was added. And the issue on appeal was that personal infliction of great bodily injury? And I'm explaining this to you because I want you to understand the significance of what happened with the change in Proposition 36. What the California Supreme Court did in looking at Mr. Oyo's case was they ruled that Raina's voluntary ingestion of that cocaine, that eliminated the personal infliction component of this enhancement, the injury enhancement. That they could not say under those circumstances that Mr. Oyo personally inflicted the harm. So it looked at other cases, and I won't go into that, but it severely limited the circumstances under which a drug dealer, a supplier, could be held accountable for an injury enhancement. And what they said is that it had to rise to the level of being just like they were almost administering the drugs themselves. And so that just about wiped out our ability to charge an injury enhancement in these cases when it comes to a drug overdose. But Proposition 36 addressed that. And they did that by adding subdivision F2, which now reads that as used in this section, a person who sells, furnishes, administers, or gives away a controlled substance is deemed to have personally inflicted great bodily injury when the person to whom the substance was sold, furnished, administered, or given suffers a significant or substantial physical injury from using the substance. So injury enhancements are back thanks to Proposition 36. Let's turn to treatment mandated felonies. So this is a new thing for the state of California. It's a new law, and it created what is now known as a treatment mandated felony. That's under Health and Safety Code section 11395. And what that provision provides is that for those people found in possession of hard drugs, again, hard drugs, remember, Schedule 1 or Schedule 2, with those main drugs being most commonly what we'll see, fentanyl, heroin, methamphetamine, cocaine base, PCP, then the other Schedule 1, Schedule 2, but excluding cannabis, peyote, LSD, those other hallucinogenic drugs, excluding those, but hard drugs. Person who's in possession of hard drugs with 2 or more qualifying prior convictions can now be charged with a felony or a misdemeanor. And we'll talk about that in just a moment. So, first offense for possession of a hard drug with 2 qualifying prior convictions is what we call an Penal Code Section 1170H wobbler. That weird name for a wobbler always makes me think of Thanksgiving when I hear wobbler. But what it actually means is that the offense could be charged by the prosecutor as either a felony or a misdemeanor, and also a court could reduce a charged wobbler from a felony to a misdemeanor if it's in the interest of justice to do so. That's what wobbler means. Penal Code Section 1170H means that it's punishment, the maximum punishment will be served in what we call here local prison, meaning a county detention facility. So, for an example, if someone got convicted of a crime that had a punishment of up to 4 years in local prison, the 1170H case, they would be subject to what we call a split sentence. A court could decide they're going to impose 2 years in custody, followed by 2 years of what is called mandatory supervision, a release from custody, but with certain conditions overseen by the probation department. The court can split it in any manner of way. It has great discretion. It could be 1 year in custody, 3 years out, 6 months in custody, 3 years, 6 months out on mandatory supervision. That is the local prison, and they're served in a local detention facility, as opposed to state prison, which is run by the California Department of Corrections and Rehabilitation. And if you go to state prison, then, of course, if following your release from state prison, you serve whatever time you need to serve, and then you're on parole for a period of time. So with a first offense of a violation of Health and Safety Code Section 11395, it's punishable by up to that wobbler level of punishable up to local prison. The possession 16, 2, or 3 years, 16 months, 2 years, or 3 years in local prison. A second subsequent convictions for 11395 are then punishable up in state prison. Here, this is important for you to remember, that no person convicted of 11395 can be sentenced to jail or prison unless a court determines that that person is not eligible or suitable for treatment. Hence the name treatment mandated felony. This is the goal. The goal is to incentivize, get people back into treatment. What are the qualifying prior convictions? I've listed them here for you. You can see there's a lot of them. It's what you would imagine for prior drug convictions, possession cases, possession for sale, transportations. You may recognize the gentleman on your right. That's Al Capone from 1932. I don't think a treatment mandated felony would have helped Mr. Capone, but I found that thought it'd be pretty cool to throw it up there. But these are the qualifying prior convictions. So if you have at least two or more of these prior convictions, and then you pick up a possession of a hard drug, you can be charged with a treatment mandated felony under 11-395 of the Health and Safety Code. Let's walk through how it plays out. So step one, you get arrested, person gets arrested for possession of a hard drug, and they have two or more qualifying prior convictions. The DA files charges, 11-395 against that defendant. That defendant will remain in custody until a judge can make an individualized determination as to the risk to the public that that person poses and the likelihood that they'll return for future court hearings. That happens at the very first court appearance, what we call arraignment. So they will stay from the period of arrest until arraignment in custody. And once there at arraignment, the defendant has the opportunity to plead guilty to that charge, pleads guilty or a plea of no contest to the Health and Safety Code section 11-395 charge. They would do that if they are seeking treatment. A defendant can always say, no, thanks, I'll take the felony. I'll take whatever punishment you want to give me, and I don't want treatment. They can always say that. Our hope is the defendants faced with this opportunity, given this opportunity, will take advantage of it. And if they do, they plead guilty right there at arraignment or any subsequent hearing. They plead guilty. They ask for professional assessment. That professional assessment is conducted by a court-approved expert in addiction who will outline a detailed treatment plan. They can interview the defendant. They can get medical records. They can review criminal histories. They can get the facts of the current offense. Anything that will guide them in making a proper assessment of what the individual needs of that particular defendant are. They'll draft up that treatment program. At the same time that the court is going to order the evaluation, a caseworker will be assigned to work with the defendant or on the defendant's behalf to try and determine whether or not the defendant is eligible for Medi-Cal, Medicare, any other relevant benefits that will then help pay for the treatment that is going to be offered, made available to that defendant. And in terms of that funding, there's other sources that are already in the works and are looking to play out. There's a pending contract with Health and Human Services Agency that's being worked through. The hope is that Proposition 1's money will also be geared towards treatment programs accessible for people that are going through Proposition 36, this 11-395 process. Proposition 1, if you don't know, that passed, it was like kind of a sleeper little proposition because it was a mid-cycle in March of 2024. But that provided money for mental health services, substance use treatment. So that's another option that is coming, so a funding source. There's currently, right now, a proposed legislation, Senate Bill 38. Senator Umberg has put this forward, and that's currently in the Public Safety Committee. And it is geared specifically as a result of the passage of Proposition 36. And it's looking to expand funding options to include drug courts, collaborative court programs. And so it's expanding that from its already in place. The Second Chance program is what SB 38 is looking to expand. It already gears money and funding opportunities towards mental health services and substance use treatment, but now it's expanding it to drug court programs. So that's the hope, that's the goal. Because we have in our county, in San Diego, what we're doing with our 11-395 participants, our defendants. They're being screened and looked at primarily through our drug court program. It's phenomenal program with a very low recidivism rate, high success rate, and it's only half full. And that's because the incentives went away years ago once the passage of Proposition 47 occurred. Now we have this incentive. We have people that are being incentivized to seek that treatment with a proven program through the courts, our drug court program, and we're looking to get additional funding through all these different sources. So it's coming together, and I look forward to seeing more of that. Getting back to the steps of what happens next. So those assessments get ordered. The evaluation report is submitted to the court, the prosecutor, the defense attorney. And then if it's all agreeable, then we move on to step 5. The defendant agrees to participate and complete the treatment program. That program can include all kinds of things. It could be substance abuse treatment. That's probably going to be a big component of it, given the nature of how they qualify for this charge. But it could be also mental health treatment. It could be job training. It could be any host of needs that particular defendant has. So it's very broad in scope, and the court can fashion it in whatever way they feel is appropriate. The court will then hold regular hearings to determine the progress of the defendant in that treatment program, whatever it looks like. How regular is determined on the court on a case-by-case basis, depending on the specific needs of that defendant. And I should have said, when the defendant pleads guilty, maybe at that very first arraignment, they waive time for pronouncement of judgment and sentencing. They set it out. Waiving time just means they're pushing it out beyond what the statutory time would otherwise be, that they're entitled to be sentenced. They're pushing it way out because the goal is that they never get sentenced, that it never gets imposed. And so they plead guilty up front. They set sentencing off into the future. They participate in the treatment program. And if successful in treatment, the charges are dismissed and the arrest is deemed to have never occurred. That plea of guilty can never be used against them for any purpose whatsoever, not even as a prior conviction for a future violation of Health and Safety Code section 11395. It's gone as if it never existed. Also, if the defendant was interviewed during the course of the evaluation, nothing he or she said in that evaluation could be used against them in the future. In that charged case, the drug case, even if they failed out, it couldn't be used against them unless they got on a stand and took the oath, and then they said something inconsistent in court that they had told to maybe the evaluator. And of course, no one gets a free pass to lie under oath. And so that's why there's that one exception. Otherwise, it can't be used against them at all. But if they're successful, that's it. Case is gone. On the other hand, if they're unsuccessful, then there's a number of things that can occur. And what it means to be unsuccessful, either they're performing unsatisfactorily in the program. Maybe they're just not benefiting at all from the program. There's no change according to the treatment providers. Maybe they're not amenable to treatment, they're refusing treatment. Or if they commit another crime after they've been given this opportunity and they're in their treatment program, they commit another crime, then the court on its own, or the probation department, or the prosecution can then move meaning file a motion, ask the court to impose judgment and sentence the defendant. If we got to that point where there was an unsuccessful participant in a treatment program, the defense attorney would be given notice, and the defendant would be entitled to a hearing. And then we would submit evidence, most likely from the treatment provider, describing what had happened, or evidence of a new crime that was committed, to the judge. And the judge would make a determination as to whether or not the person is still amenable to treatment under this program. If the court is convinced that the defendant is no longer amenable to treatment, has refused treatment, or has committed that additional crime, then the defendant is in fact sentenced in court. And with the exception of committing a new crime, meaning if any of the other circumstances were the reason for imposition of sentence, the refusing treatment, being unamenable, not making any progress, just not working for them. If those are the reasons, the court can still, the grant of probation, so he's being sentenced, the court could say, I'm sentencing you to period of time in probation, and I'm going to re-refer you to treatment. The court cannot re-refer to treatment when the circumstances are the commission of a new crime, but short of that, any of those other reasons, they can re-refer to treatment. It's yet another opportunity. What is lost is that ability to just have all the case dismissed and having the arrest deemed as if it never occurred. But still, the goal remains, let's get as many people into treatment as possible. Let's give them the best opportunity that we can to have them deal with the issues that they need to deal with and have a successful outcome in the end. The court always has that discretion. So it could be treatment, could be probation, it could be jail time. Again, we're talking about the failure of participation in the treatment program. It could be jail time or treatment or combination of the two. But that is limited to those circumstances where the program didn't work. I want to turn now to, that's a drug of Proposition 36. And I want to turn now to the theft component of Proposition 36 and the changes made there. And I'm going to start by playing this video.
What was slightly smash and grab robberies across the state, including right here in San Diego County, the San Diego DA is now taking this.
Significant of all, who spoke to DA from the stepping today and to just like so much. Take a look at this disturbing surveillance video showing two suspects snatching glass casings at a National City Mall to steal jewelry.
It's the worst time for things like this to happen.
The robbery comes amid a string of smash and grab thefts in Los Angeles and San Francisco. District Attorney Summer Stephan is now teaming up with businesses and police to prevent more from happening here.
We did a case recently with $700,000 worth of loss. This is not a small crime operation.
The CDC's Organized Retail Crime Task Force also led an operation this week to combat these organized thefts at 10 locations in San Diego and Orange counties.
Many of our members are singing in businesses, the mom and pop shops. And for them to be terrorized by groups that are doing together and organized to take away from the independent businesses that serve our local communities, it's extremely serious thing.
The Stephan Take One challenge has been Prop 47, which says theft under $950 cannot be charged as a felony, no matter how many times the theft is repeated.
Criminals who are perpetrating these crimes know about Prop 47. They know about the ins and outs, the amounts of property that they need to steal before something rises to a certain level. What is slightly.
So, as you just heard, Proposition 47, which was entitled the Safe Neighborhoods and Schools Act, passed in 2014. And some of what happened, the primary effects of the passage of Proposition 47, is that it raised that threshold for the charging of a felony theft from $400 to $950. And so now before a prosecutor can charge someone with a felony theft, it had to be above $950. It used to be $400. So that included shoplifting, grand theft, receiving stolen property, forgery, fraud. And the other thing it did in Proposition 47 was it eliminated the ability for prosecutors to charge repeat those chronic offenders with the thieves with a felony, no matter how many times that they stole. And so you heard in that video that these perpetrators would often, they knew that as long as they stayed under $950, they would not get a felony offense. We've had cases with individuals with calculators going through stores, making sure they don't exceed that $950 threshold, because if they get a misdemeanor, you might be thinking, well, a misdemeanor is still a crime, right? A misdemeanor still carries some punishment. But the realities of the way the system works is that if it's a misdemeanor, they're going to get a citation, which means show up in court on a future date. They're not booked into jail. And then when they don't show up for that misdemeanor citation for that petty theft, then the court will issue a warrant, but nothing happens. There are no consequences. A warrant goes out, they don't show up. Again, if they get arrested, it's not bookable. They get released with a promise to appear, and the cycle continues. And we've had defendants 10, 15, 20 failures to appear in court on misdemeanor offenses. Why? Because they know there's absolutely zero consequence. And so the unfortunate combination of that, what Proposition 47 did with raising that threshold and eliminating the ability to charge felonies for chronic repeat offenders, is that it emboldened these thieves. And they continue now to perpetrate without any real consequence. Something else that affects the ability, or did affect the ability of prosecutors to charge these repeat offenders, is known as the Bailey Doctrine. And this has been in existence for quite some time. As you can see, the case itself is from 1961. And what the Bailey Doctrine holds in the law in California is that you can charge multiple acts of petty theft as a felony if you can show that these multiple thefts are part of one overarching scheme or plan rather than separate offenses. Well, that's actually harder to do than you might imagine. One example where it might apply, let's say you have someone who is embezzling from their employer. And so they're stealing small amounts on a regular basis from their employer. You can make a pretty strong argument that that is one overarching scheme or plan. And therefore, you can take those individual acts of embezzlement that maybe fall under $950 and aggregate them, add them up, and get to over $950 to charge that single felony offense. But what about a situation where a defendant goes into, let's say, Target on Monday, steals $500 worth of electronic equipment, and then maybe on Wednesday they go into Gaslamp Liquor and they steal $800 worth of food. Maybe the following week they see a package, $80 worth of clothing in an Amazon box on your porch. And each of those times they steal those amounts. We would be very hard pressed to prove that those repeated acts of theft are one overarching scheme or plan. And so those would have to be charged as three separate petty theft misdemeanor crimes. And we would not be able to aggravate because of the Bailey Doctrine. Well, Proposition 36 addressed both the chronic offenders and the ability to aggregate. Aggregation of value, or adding them up. Now, with the passage of Proposition 36, we can take those separate acts of petty theft and aggregate them together to get that one single felony. So that $500 from Target, $800 from the liquor store, the $80 from the front porch items. Now you're at over $1,300. You're past the $950 threshold, and you can aggregate and charge instead a single felony theft, a grand theft, as opposed to a petty theft. And the other thing that Proposition 36 did was that it now allows prosecutors to charge those chronic repeat offenders who have multiple convictions. So now if you commit a petty theft with 2 or more qualifying prior convictions, you can be charged with a felony. First offense, first conviction is a local prison. Remember, county detention facility, subject to a split sentence. It's a local prison wobbler. My favorite word again, punishable by 16 months, 2 or 3 years in that local detention facility, or up to 1 year in county jail if charged as a misdemeanor. A second or subsequent conviction for a petty theft with 2 or more priors will then be the same punishment, but this time in state prison. But the qualifying prior conviction. Here's the list of those prior convictions, those qualifying prior convictions. and it runs the gamut of what you would expect from any theft-related offense. The gentleman you see to your left, the infamous John Dillinger. Mr. Dillinger would certainly, if he stole your Amazon package today, would qualify given his prior robberies and car thefts with a petty theft with prior felony charge under Penal Code Section 666.1. So much like in the context of the drug provisions, even with theft, and one thing that the drafters of Proposition 36 recognized from the outset was that all these things are connected. The substance abuse, the homelessness, the drug theft. There are theft rings that take advantage of the desperation of those who are homeless, that will then encourage them to steal, or they will be encouraged by their own addictions to steal, and they would fence those stolen items off and supply their own drug habits. But they're people that are chronic offenders. All of this is connected. And just like in the drug context with the goal of getting them into treatment, the same thing is the goal under Proposition 36 when it comes to these repeat theft offenses. And that is that these city attorneys, prosecuting attorneys, county probation department, they have the ability to create diversion programs and deferred entry of judgment programs to address these chronic thieves and hopefully get them the services that they need to break this cycle. And just quick on the difference, a diversion program just means it's a pre-conviction. They don't plead guilty up front. Pre-conviction program. They just kind of push off the criminal proceedings into the future, and the court will order a number of different conditions to be satisfied. They could be what you would imagine them to be, right? Anti-theft classes, maybe cognitive behavioral therapy, maybe volunteer service, community service, restitution to the victim. A whole host of different conditions can be put into these diversion programs. And if successful, case gets dismissed, the charges get dismissed, it's all gone. A deferred entry of judgment program is the same thing in terms of the conditions that can be ordered, but it requires a plea of guilty or no contest up front. And then they push off the sentencing into the future, much like in the context of the 11-395 drug charge. This is preferable in the eyes, I think, of many of us prosecutors, because you imagine that diversion program where we push off the case into the future, and let's say, unfortunately, things don't go as we all hoped, and the person fails out, picks up new charges. Maybe we're a year down the road, and now we have to go back and try and prove the crime that happened a year ago, some petty theft, witnesses who knows where they may be, if they're still available, where the evidence is. So the deferred entry of judgment, let's just get that conviction up front and then get the treatment ordered, the treatment that's needed for that individual. Then, if unfortunately, if they fail out, we don't have to try and prove the case, we go forward with our sentencing after that. But same conditions could apply in terms of what we want that defendant to do. But it's an individualized determination by the court. And the court will make that determination based on how willing that defendant is. What are the needs of the defendant? How willing are they to participate in and complete their treatment conditions? It could be mental health services that they're needing as well. And last up, I'm just about wrapping up. I have the two enhancements that relate to the theft component. The first one being the excessive takings enhancement. This actually used to be the law back in 2017. It just quietly sunsetted. So some of our laws just expire after a certain period of time. This is one of them. It just went away. It's now back with Proposition 36, and that's the excessive takings enhancement. And now they changed the thresholds a little bit, the dollar thresholds, and I'll show those to you. But when an offender, a criminal defendant, takes, damages, or destroys property during the commission or attempted commission of a felony, and that additional punishment, if it exceeds that loss, the value of the property taken or damaged or destroyed, If it exceeds $50,000, that's where we get the first enhancement of an additional 1 year on top of whatever that felony was. Maybe it was a burglary that they committed. Maybe it was a robbery that they committed. Maybe it was vandalism, felony vandalism. But the damage was over $50,000, you get an additional 1 year. In that video I showed you with District Attorney Summer Steffen, she was talking about the case we had here in San Diego County that exceeded $700,000 worth of loss. So here we would have an additional 2-year enhancement in addition to whatever charges were involved in that case, where there was a grand theft or vandalism and so forth. That's the excessive takings enhancement. The other enhancement is the acting in concert enhancement. And what we know to be true is that when you get multiple individuals all with the same intent to commit crime, it increases the likelihood, one, of successfully completing the crime, but two, the harm and the damage that can be inflicted with multiple people sharing that same criminal intent, operating together to commit that crime. And so this enhancement is when you have a perpetrator acting with 2 or more individuals to attempt to take, damage, or destroy property, you can get an additional punishment of 1, 2, or 3 years. And that enhancement may be imposed with additional enhancement. For example, if we have that $700,000 case, right, you can get both the excessive takings enhancement because the dollar amount of the damage and or the value of the property is so high, you get the excessive takings enhancement in addition to, let's say, grand theft. But then if you had 3 people, more than 3 people acting together to commit that crime, you can also then get an excessive takings enhancement added to that as well. Let me here.
So what we try to do is actually make sure that we move into full action.
Will bring balance to the criminal justice system. It strengthens the police on youth offenders for theft and drug crime, but he hopes it will open the door to recovery for many people rather than locking them up.
It still provides those first and second chances when people are making streets to recover, to not have to go to prison.
The county's top is referring to drug courts.
This is an incredible thing with a 7% recidivism rate.
It's already an option in San Diego, offering therapy, drug testing, and detox. But the program, the video says, is only about half full. He hopes Prop 36 changes that by making drug court the alternative to a felony instead of a misdemeanor. Changes are headed to the public justice.
And just hot off the press, just last night, I got some numbers. So let me just give you that in terms of San Diego County and our charging of Health and Safety Code Section 11395, that treatment mandated felony, as well as the petty theft with 2 or more qualifying convictions, that Penal Code Section 666.1. And so this is for the period of December 18th, that's the date the law, Proposition 36, went into effect, up to February 15th. And so in San Diego County, countywide, we had 318 cases submitted to us for Health and Safety Code Section 11395. And of those, we issued approximately 69% of those cases as an 11395 charge. That's roughly 219 individuals for 11395 in that short time period. For the petty theft with 2 or more qualifying priors, we had 111 cases submitted to our office for prosecution. And again, we issued 69% of those. So roughly 76 of those cases got issued by us. And the reason not all of them were issued, that could be a whole host of different reasons. We may have opted to charge different charges. There may be the evidence wasn't sufficient for some, and some of the cases were rejected. Sometimes we can redirect cases from our office to the city attorney's office, and they'll take them as misdemeanors. But still, 69% of the submitted cases, both for the treatment mandated felony and the petty theft with priors, we've issued those. So even with just the drug component, 219 individuals, that means 219 individuals now have an opportunity to take advantage of treatment that they would have not otherwise been offered. Because before Prop 36, they probably would have been given a citation. Maybe if they showed up to court convicted of a misdemeanor, they would never have a probation officer, an active probation officer overseeing them. They would just have some generalized conditions of probation. Nothing would happen. The cycle would continue. So this is the hope with Proposition 36, breaking that cycle, making improvements in our communities, both for the residents, the visitors, the business owners, and most importantly for the individuals who are coming through our criminal justice system and giving them an opportunity to take a different path, get the help that they absolutely need. That's my presentation for you this morning. I want to thank you for being here and your attention. I'll turn it right back over to Molly.